So welcome to all of you. This is really a terrific Robert Weil lecture. When I was a relatively young lawyer, I came into the sphere of Robert Weil and learned that he was a compulsive educator. Wherever he went, whatever he did, he wanted to educate lawyers. He was the central Rudder Group author with Weil and Brown. When he became a retired judge and he started the Gold Card, if you remember the Gold Card, he was the education director of the Gold Card, and he would collect and send out twice a year a stack of information about current events. And it just seemed to several of us when he passed that finding something to do to honor his memory had to be involved in some way with legal education. And so we've had now for at least, this is the 12th Weil lecture, maybe it's more. We haven't probably kept very accurate records. 17? Okay. But it's a terrific way to honor a really legendary judge. And the person who is here tonight to fulfill that obligation, Carrie Menkel-Meadow, is herself a true pioneer in dispute resolution for her teaching currently at UC Irvine, formerly at Georgetown, formerly at UCLA, visiting professor at Harvard, at Stanford, at the University of Pennsylvania, for her writing, an admirable body of scholarship in mediation and international dispute resolution and allied fields. She's been honored many times for her scholarship. Most recently, in 2018, the American Bar Foundation Outstanding Scholar Award was bestowed on her for, quote, decades of work in creating, supporting, and internationalizing the field of ADR. And she was also honored for the very first award for scholarly writing given by the ABA Dispute Resolution Section many years ago. She's also respected for her leadership in the field. She was the director of the Georgetown Hewlett Program in Conflict Resolution. She was the director of the UCLA Center on Conflict Resolution. She was the, I believe, director of the CPR Georgetown project on provider ethics, among many other things. She's also a remarkably collegial person. She will go almost anywhere to share her knowledge, and we appreciate her willingness to work with many organizations in doing that. This is actually the second Weil lecture that she has delivered. About 10 years ago at the State Bar Convention in Anaheim, she and Bob Mnookin shared a stage. He had just written his book on bargaining with the devil, and they talked back and forth about the pros and cons of fraught mediation. So it's, I know that Bob Weil would really be proud to have her be the Robert Weil Lecturer this year, and it's my pleasure to introduce Carrie Menkel-Meadow.
Thank you so much, Rich. So if you will all bear with me, I'm going to do a few little introductory things too. It's a great honor to be here. I could almost see my first house in LA, which direction up there. So it's really great to be back in my old neighborhood and where I practice law. And I was a trial lawyer. I always say that to people when I promote ADR. I was just saying many years ago when I first spoke to, I think it was the Beverly Hills Bar Association, promoting mediation, various lawyers got up and said, why don't you go back to social work, Professor Menkel-Meadow? And I had to tell them how many years, I want to see my scars, that I tried cases right here. So I came to ADR, and I'll say a few words about that in a moment, from having been a trial lawyer and knowing what trials can do and what trials can't always do. And thank you to Rich, one of my friends and mentors in this field. It's very funny because Rich made a tape for CPR some years ago illustrating mediation. My good friend Steve Goldberg, who's a professor at Northwestern, was the mediator. And Rich played one of the lawyers. Without the gray hair, I see him twice a year, at least, if not. I see him, now I get to see him live again. But For, I think, almost 25 years, my students have been watching a tape that CPR produced that is really terrific. Persando versus High Tech. And it still works. The computers are a little old, but it's an international dispute about a distribution contract that went bad, and there are some very interesting contract issues. And for those of you who do any teaching of any kind, I really recommend it. This is the star. And he was a really, really good lawyer in the tape. And I've always respected, Rich was one of the first major lawyers I knew that left his quite considerable career as a practicing lawyer to be a fabulous world-class arbitrator and occasionally mediator too, right? So it's a great pleasure. And I also want to say that when Dorothy Nelson, who is also a dear friend and mentor, founded the Western Justice Center, one of the things that happened at the Western Justice Center for many years, I don't know if you guys know this, was she invited a mentor to some of you, at least Jeff in the audience here, Frank Sander, who some people call me the mother of ADR. That's very nice. Actually, Dorothy was in her own way. But Frank Sander is often credited with Roger Fisher at Harvard as being the fathers of alternative dispute resolution. And so Dorothy asked Frank to form a group of senior mediators. And the Western Justice Center actually supported us for about 10 years. There were a group of about 25 of us self-appointed first-generation mediators. And we met at the Western Justice Center for about 10 years. Then we shifted to Boston after Frank became quite elderly. And we met for many years at MIT's conference center so that Frank could still come. And Frank has just died in the last year. Jeff's about to go to his memorial service. I can't go because I have to be there the week before, so you'll pay my respects to Allison and Tom, his children. But the Western Center for Justice was our home. And I'm going to talk about some of those issues because what the senior mediators did was, it was a group of us who, in a whole bunch of different fields, Frank was very clever because he invited a number of us. There were about 5 or 6 academics. I call myself a pracademic because I teach ADR in various ways, and I also teach lots of other things, but I also practice. And so the whole time I've taught ADR, I've also had a little practice on the side. Used to be bigger in the summers, and when I was in sabbatical, I never let it affect my teaching schedule. But it was very important in that group to have people that were both theorists of the ADR processes, but also people that practice. So we had people from, not many, but we had a few from large commercial practices, several mediators that did primarily labor and employment, 2 family mediators, I'm trying to think what other fields. And so once a year, we would go off and have a retreat weekend, and the Western Justice Center was our wonderful spot for many years. So I have very wonderful memories of a lot of the ideas that came out of that. I'm going to talk about a couple of little different things tonight. I'm going to watch my time. Some of you, how many of you were at the USC conference in March, which I keynoted? Okay, because I don't want to repeat myself too much. I will take Q&As at the end, but I also invite any of you, I like interactive lectures, if you have any question while I'm talking, to just raise your hand. So what I want to do tonight is a couple of things. One is a little bit of theory of where this ADR stuff came from. And my topic for tonight is the ways in which some of the ADR processes are becoming blended. If you were at the March USC conference, you heard me do this mostly for international dispute resolution, but it certainly has been happening, if not more so, in domestic practice. So I want to talk to you just a little bit about the theory of that, what it means when processes are blended, and talk a little bit about some of the techniques in which that's happening that I think are good things. And I'd love to hear from you. You can learn from each other what you've been doing to blend processes or not. And then I'm going to talk about some of the problems I see when some of these processes are put together without people thinking about such things as ethics. I'm an ethics professor. And some of the consequences that may flow from people both being creative in putting processes together, but not thinking about some of the downsides of that. And then I'd love to hear from you what you are doing, what questions you have, and to share with each other. So I'm going to start. I promised we were talking about being political or not. I'm having PTSD today. So if we were about to say, you might have asked me to talk about something else, but Anita Hill was a student of mine when I taught a summer program for brand new professors. And as emerged in her hearings, very famously, she confided to one of my other students in that program what had happened to her. And so he was actually one of the people that did get to testify. So unlike today, as some of you may remember 27 years ago, there were panels of people giving testimony all weekend. I was in my home in Los Angeles at the time, as I was this morning. It was totally bizarre to feel deja vu all over again. And I'm mentioning that because I was a Washington mediator and lawyer for 15 years, and I'm still technically on the DC Circuit Court of Appeals mediation panel. So I'm a Washington lawyer too, and I've been in those hearing rooms. I participated in the Bork hearings. And I'm mentioning in this context because how many of you saw any of it this morning? What you saw today is what I want to talk about today. The problems sometimes of blending processes. So I'm a law professor. We go to Socratic mode here. What kind of process was that this morning? What was that? Messy. It wasn't a usual hearing. Everybody was busy saying there are precedents. There are. Roy Cohn, anybody? You're really old? Precedents for having an outside counsel come and do the questioning, but it's not the norm by a long shot. In a confirmation hearing, of which I witnessed many in my years in Washington, generally speaking, there is, as you heard, an FBI background check. You also heard today, I hope, the FBI does not come to conclusions, generally. They get a lot of information about people, and then they report factually to whoever the ultimate fact finder is, or the confirming body. I heard today, I didn't know this actually, that the FBI reports for confirmation for federal judges in the Supreme Court actually go to the president too, in addition to the Senate committee. I have to check that. Somebody said that today. I'd never known that before. But that wasn't a usual hearing. And as you know, they all hired a sex crimes prosecutor to ask the questions of Dr. Ford. And if you saw, she got to read her statement, which you might say was something like a direct testimony, but not really. It was a statement. And when she was done, her questions were asked by a prosecutor. And even though she tried to do it gently because the Republican 11 men thought they learned something 27 years ago, I don't think they did, but they think they did, and they wanted to change their process. So they made a lot of process decisions today. I am a process design expert, so I'm always very interested when people take the processes that we already have, Senate hearings, trials, ADR, and they try to work with them. And as I tell my colleagues in our faculty meetings, the decision rules really matter. Majority vote, plurality vote, supermajority, and the process rules really matter. And so what the Republicans did this morning was to try to change the hearing process to not look like they were doing a tough cross-examination of Dr. Ford, as they did do of Professor Anita Hill. And actually, I think it backfired on them, which you can see if you saw this afternoon when Lindsey Graham said, enough, I'm taking over, I want to go back to the old system. And after his little explosion, he then did what he thought was both a speech and cross-examination. So it did sort of become quasi-trial or not, but I just want you, whatever you think of the merits of it, you know what I think of the merits of it, to look at what a mess it was, because it didn't have process purity. And because people were making decisions to alter the process for political reasons, not to get at the truth, and it has consequences. So here is my quick little lecture on theory. How many of you ever read any Lon Fuller when you were in law school? Good. You didn't? So Lon Fuller is the real father of ADR. Lon Fuller was a Harvard law professor, and in World War II, he served on a variety of President Roosevelt's commissions setting standards, and through that, he became a labor arbitrator. And he was, when he went back to Harvard, he was a jurisprudent. He wrote a lot of fancy theory. He was a contracts professor. He was a brilliant man. And when he went back to Harvard, it was rare at the time. He was a brilliant jurisprudent, but he also continued to practice. And in all of my writing that I do, and in my, I have a brand new, I'm not pushing it because it's too expensive, third edition of my basic ADR textbooks being published in a couple of weeks. And there's a lot of Lon Fuller in that book. Eventually, as a Harvard professor, Lon Fuller wrote 3 or 4 separate articles, each of which describes the integrity and the specificity of each process that we use. When do we need adjudication? When we need a decision? When we need to find out the truth? When the truth's very important, and when we need a decision. So the classic examples of that for my lifetime: Brown versus Board of Education, and I would add, who knows how long it's going to survive, Roe versus Wade. Cases that were constitutional, of great import, and very divisive in the society, and somebody actually needed to make a definitive ruling. And those cases came up, both of them, with decades-long worth of strategy on the part of the lawyers to have enough factual development. For some of you, you may know the Brown versus Board of Ed was one of the times in which the Supreme Court looked at social science evidence, the famous dolls study, to determine that children playing with black dolls versus white dolls were demonstrating how they understood themselves, black children, to be inferior to the white dolls. Very important in the ultimate decision. And Roe versus Wade also actually pioneered by a bunch of Yale law professors, and I didn't realize until quite recently that one of the original plaintiffs were 2 friends of mine, Louise and David Trubeck, who are now retired professors who were at Yale at the time, and they were some of the first plaintiffs. You don't see their names on Griswold or on Roe versus Wade, but it was part of a strategy to get enough fact-finding to the courts in a trial setting, and then through briefs that had more than just legal cases. So Lon Fuller wrote a lot about when you needed adjudication. And the thing that made him really great was he said, we don't always need adjudication. So well before ADR became something that Bob Weil did, or Rich did, or I did, he said, in my experience during the war, when it was very important for labor disputes to be resolved and also for prices to be set when we were trying to supply our armies, and we couldn't have a lot of disputing about that. So there were contract boards that did fact-finding and then set prices. And from that experience, he said, arbitration is a process that has its own integrity, its own rules. By integrity, he meant a sense of purity of what it's trying to do. And arbitration is useful in a couple of settings. Collective bargaining, when there's a collective bargaining agreement, when there's a contract, and this would be true in business, commercial arbitration too, when there's a contract and there was a meeting of the minds as to what that contract means, and it's better to get the parties who understand the meaning of that contract to come to a hearing in which they can get a decision. They want a decision. They want somebody to say, you're right, you're wrong, you pay damages, or you do this. But the people in the dispute are the ones who framed the contract. And Lon Fuller famously said, you may have heard it if you do any labor work, the purpose of a labor arbitration is to enforce not just the contract, but the law of the shop, meaning the understanding on the floor of the shop, of the labor place, what these terms in this collective bargaining agreement mean. And we don't want to go to a judge. I mean, we do go to judges in labor disputes, but generally we choose arbitration in labor settings because we don't want to go to a judge who's not familiar with our factory or our school if we're in a teachers union, or our hospital if we're in a hospital union. We want to have an arbitrator who will decide, but is someone who's an expert, who knows our shop, who knows our contract, who knows what we're trying to accomplish. And of course, as you all know, if you arbitrate, the other thing that arbitration offered, unlike court, was privacy. So that's the other sub-theme of my talk tonight. I've been working a lot, both internationally and domestically. What kinds of disputes belong in the public sphere so that people can have access to them and interested parties can have some ability to participate? For those of you there in March, last year at USC, big issues in state investor arbitration right now has been the role of amicus, the role of labor groups, of environmental groups, of groups who feel that an investor-state arbitration decision is affecting not only the national policy of the country that's in the arbitration, but parties outside of whatever the investment, either the treaty or the contract is. So there's a big question about what kinds of disputes need to be in the public sphere, and you can look at today as another example of that. A lot of talk about how Dr. Ford wanted confidentiality, and other people saying we, the American public, have the right to know about this. And you can understand why she didn't want to go public. It's very painful. And so people choose processes so they can choose a different way to do it. So I think it was over 20 years ago now. Some of you may be familiar with this litigation. There's been a lot of mass tort litigation. And when the Dalcon Shield, everybody know what I'm talking about? That's like, not so some of the people in the room. Dalcon Shield, fortunately for me, I never used one, was a form of birth control. It looked like a little fish. It was a little wire thing, and women inserted it in their bodies. And the biology of it was when this little metal thing was in your body, the fertilized egg wouldn't actually attach to the uterus, and it was a way of doing birth control. For my generation, that's when it happened. It was very important because the first round of birth control pills were pretty dangerous. So when the first birth control pills came out, they had very high levels of hormones, and women were having strokes and heart attacks. So somewhere in the 60s, late 60s, early 70s, the Dalcon Shield was considered to be a very effective way for reproductive freedom. It promised women they wouldn't get pregnant. And so Planned Parenthood and virtually every student health office in every major university in the United States started to offer Dalcon Shields. A few years later, it turned out not only did they not prevent pregnancy, their pregnancy prevention rate was about 92%. This was one of those cases that happened because there was a whistleblower within the Robbins company that sent the data about how bad the product was performing to plaintiffs' lawyers, who then sued on behalf of a lot of plaintiffs. There was a big class action, and the Robbins company went into bankruptcy. As a result of that, out of bankruptcy, two names that may or may not be familiar to some of you, Ken Feinberg and Francis McGovern, also early fathers of not just ADR, but dispute system design, were both asked by the bankruptcy court and Judge Merridge in Virginia to construct a dispute resolution process so that the women who had claims could testify in private. This was after the bankruptcy happened. So there'd already been a bunch of public trials with very big verdicts. And for those of you who are litigators, the other thing this case is known for is that the Dalcon Shield litigation was the first time that a class action was certified in a mass tort. You know why? The defense asked for it. The Robbins company's lawyer said, we want to have closure. We want to know how many cases we have. We want to know what our liability is. So it wasn't the plaintiffs' lawyers who'd been asking for class certification in all kinds of medical device cases before that. But I used to teach civil procedure. If you take a look at Rule 23, when it was drafted in 1938, it really was not intended to cover torts because the theory was everybody's different. When you have an injury, the injuries are going to be so individualized you can't really have class litigation. So anyway, among other things, the Dalcon Shield litigation led to the first class action because Robbins' defense lawyers asked for it, and they made a strong argument for class action certification to be good in mass torts. That was the first case. In the 80s and 90s, I mediated a lot of the big asbestos cases through the Wellington facility. Did you do any of those, Rich? Yeah, I think CPR, Center of Public Resources, was the administrator. So why am I telling you this? Because those arbitrations, I did about 300 or 400 of them. I was the first. Initially, all the arbitrators that were chosen were labor arbitrators. They were all men. And it was either Ken Feinberg or Francis McGovern, both of whom knew me, and a bunch of other early mediators said, I think for this kind of women's health issue, we'd better get a couple of women trained. So I was trained, and my colleague Carol Liebman, who just retired from Columbia as a mediation professor, and I did the first 200 cases here in Los Angeles, then in Baltimore, Maryland, then in Australia, and then in Holland, because those cases, the Dalcon Shield traveled the world. So the reason I'm telling you this story, I was an arbitrator in those cases. And when I was done, I've written an article, it's all public, it's in the Loyola of Los Angeles Law Review, in which I reflected on a lot of things about that process. But one of the things was I thought arbitration was terrible because the bankruptcy court in its deal with Robbins and in the dispute system that was designed said that women would get a fast-track trial-like proceeding, and then there was a damage award that I could give them that was capped at a very low amount of money. Initially, it was only $10,000, and then it turned out the trust from the bankruptcy had more money than they thought, so we went back and awarded people more money, but the people that went into that program never got more than $25,000, some of them for extremely severe injuries, loss of children, having children they didn't want to have. That was a whole interesting question about ADR because the bankruptcy agreement said that state law would not apply, that there was the law of Virginia was going to apply. Virginia did not recognize a wrongful life claim. But I, as an arbitrator here in California, if someone actually had had a wrongful life claim, I gave them a maximum amount. And I was as powerful as a Supreme Court justice when I did those cases because there was no appeal at all. Those were final. So I kept track of all of my awards, and I was very careful to be sure that people that suffered the same injury got the same amount. So advantage of that process, designed as a hearing, so people would have to testify about what they actually suffered, but private, so private arbitration. But I decided at that time it was a terrible process. Many of those women, by the way, these hearings were mostly 15 to 20 years after the injury because the bankruptcy process took that long to get organized. So like Dr. Ford today, these women had to come in and testify about events that had happened a long time ago. And most of them, whether they were suffering from trauma or not, had sort of gotten over it. What did they want? They wanted an apology from the Robbins Company. And so I wrote articles and wrote letters to Ken and Judge Merridge and said, next time you have one of these, you really need a really good professional process designer because given how these were structured, each one was no more than an hour, it would have been much easier to structure something that looked like a mediation. And this is a place where a hybrid sort of thing might have worked. So a little conversation between the parties, some representative of the company would come and say, we're sorry, and look at the person's case. And then they could negotiate for a little while. Remember, there's a cap. So we're dealing in a range that, I can't award $1 million. There's a range. Let the parties negotiate for a little while if they want to. Let the company say something meaningful, that's an apology. And I think a lot of those people would have been a lot happier than getting some, I used to write 3-page arbitration awards, getting some decision, and that's it. And they were still upset and angry because they never got anything, any admission of anything from the company. So I began to think at that time, there's more than just litigation, arbitration, and mediation. There are times when you could put those things together very, very productively, and I give that to you as an example of a place where if it was well structured, I think you could have combined a med-arb sort of thing. So Lon Fuller wrote a lot about arbitration, and then he wrote in the USC Law Review, in the Southern Cal Law Review, 1973, the classic, if you've never read it and you're a mediator, you must read it, the classic theoretical expression of what mediation is supposed to do. And if you've all heard the phrase, the purpose of mediation is to reorient the parties toward each other, that's where it comes from. And Fuller was trying to decide in these 3 articles, analytically, when do we need adjudication? When do we need arbitration? When do we need mediation? What are we trying to do? And in mediation, he said, again, probably very important in a lot of labor disputes if the parties are going to stay together. If the employee is going to stay, if the employer is going to stay, we have to have a place where they can talk to each other. Obviously, family disputes, because whether they're ending or not, if there's a divorce, the parents are still going to be parents of their children. They have an ongoing relationship. So for those of you who've heard that mediation is particularly important in ongoing relationships, that's where it comes from. And he also said in commercial relations, which many of you mediate and arbitrate, if there's an ongoing vendor relationship with people and suppliers, you want to be able to keep those relationships going well. And so it's really from Lon Fuller that a lot of modern commercial mediation begins. And he also said, very important to me, because I now specialize, both in my practice and in my teaching, in complex, multi-party, multi-issue problems, not just plaintiff-defendant. All of you that mediate, either privately or for courts, I want you to tell me a single lawsuit you're working on now, other than a criminal case, that is simply a single P and a single D. Because in almost every case, behind the D is an insurer, and with the P is employees, family members, other people affected by whatever's going to happen. So I'm interested now in looking at places where the issues are complex and intertwined and there are many parties. And Lon Fuller has a wonderful description of that. He said disputes that are complex and multi-party are like spider webs. They are a web. That's before the World Wide Web. They are a web. They're not a football field. They're not bilateral. They have lots of little elements. And if you tug on one part of a spider web, it's going to have a little effect over here. So the beauty of mediation is that you're not confined by evidence rules. You're not confined by what I have called in my writing brittle outcomes of courts. What's a brittle outcome? You win, you lose, you pay damages, or even an injunction. It's brittle. And the beauty of mediation is that it allows you to work on the different elements of the spider web and try to see the relationship of issues to each other and to try to find some solution that's not brittle. So Lon Fuller's articles provide a theoretical backdrop for the argument that some of us make that each of these processes has its own rules and integrity and ethics. A trial is not a Senate hearing. A Senate hearing is not an arbitration. An arbitration isn't a mediation, and a mediation, so the purists would say, should never be an arbitration. Now, quickly before I go on, how many of you have used hybrid processes in your practices? Med-arb? Arb-med? Okay, so that's the most common form these days. I'm sure in your practices and certainly in mine. I've been mediating for a long time, 35 years, early 80s. And I've mentioned to some of you out there, ironically, it's very interesting for me as a sub-note. I'll just mention it. We can talk about it during the Q&A if you want. I'm very interested in the culture of ADR, and I mean that both domestically, in California, in the United States, and internationally. So I started in Northern California, even though I was down here living in Southern California. Why? Because some of the judges in the Northern District of California in the federal court were very interested in ADR. And Gary Friedman was a mediation trainer in the Bay Area who was doing family mediation. And so my model, working with Gary and the courts in Northern California, was a non-caucus mediation model, keeping the parties in the room together as long as possible, especially in those Fullerian cases where there's ongoing relationships. If the people have to deal with each other, what is the point of Henry Kissinger shuttle diplomacy type mediation, going to talk to the parties and then telling them what to do? That, by the way, is what Ken Feinberg does. Ken Feinberg's an old friend of mine. We used to debate, I don't know if Rich remembers, for a couple of years, CPR had Ken and I on panels, and I would very provocatively say, Ken, you're a great dispute resolver. What you do is not mediation. He never keeps the people in the same room. He goes and interviews, and he got started, some of you may know, he got started by working for Senator Ted Kennedy. There was a little problem in Boston, and he sent Ken up there to try to resolve it. So he fell into the field with great talent, literally fell into the field without any training, and he was quite terrific, and people still hire him to do what he does, but it's not mediation. He interviews the parties. He's a very smart man. He figures out what a good solution would be, and then he tries to sell it to them. That happens in international shuttle diplomacy all the time. Henry Kissinger was famous for it. James Baker took a totally different approach. I'm actually writing an article to contrast James Baker and Henry Kissinger's models of mediation on the international stage. Very different approaches. But that's not mediation, says me, because I do the non-caucus model. So I moved to Washington, and both San Francisco and Washington, D.C. are the two federal courts that had the earliest and strongest ADR programs in the courts. And my good friends, part of the senior mediator group, Linda Sinker and Michael Lewis, were doing a lot of training of D.C. mediators, and they were teaching the caucus model. So we spent years. I then subsequently became a trainer for the D.C. Circuit Court also. We had two competing models of mediation. And so one thing to think about in your practices is who trained you? Because my guess is whoever first trained you framed your conception of what a good mediation is and how it should be conducted. And if you do nothing else tonight when you leave me, I want you to be thinking about what different goals and purposes come from making different choices. Are you doing it intentionally with intention to accomplish certain goals with the parties? Are you doing it just to settle the case? Have you thought about what their relationship is to each other? And have you thought about what you might get out of using different processes? And so for me, when someone calls me up and says, could you help me mediate a dispute? I say, well, tell me more about it. And I interview the parties, and then I say, here's the things I can offer you. So I started to say, when I got trained in the beginning 35 years ago, I was a pure facilitative mediator. I help the parties communicate with each other. I teach a lot of creative problem solving in law schools because our students are taught not to create, but to analyze and tear down and be critical. So I do a lot of creative thinking exercises, and I do that in my mediations. I try to get the parties to come up with creative solutions. And so when I get a case, I will try to figure out if that's possible or not. Probably in the mid-'80s, when I started doing Wellington asbestos cases, probably the first time it happened, I, like many of you, became sensitive to the market. I offered what I wanted to do, and in a very, very big Lloyd's of London, over $1 billion at stake case, the lawyers said to me, we will give you 12 months, Menkel-Meadow. It was very nice. For those of you who live in Westwood, we met at what is now the W Hotel. What was it? The Marquis. We met at the Marquis for 1 year, once a month. Marquis liked me so much because I brought so much business to them, they started to send us really nice bottles of wine. How am I doing? I'll stop soon. One question we can talk about is the role of food in mediation. So seriously, because I had never allowed liquor at any of my meetings before, but it actually worked a little bit. And in that case, it was a very, very big case between several insurers and several asbestos producers, huge. And they had appeals pending in 3 circuit courts, federal courts. And they said, Menkel-Meadow, you're a professor. We all would like you to do an evaluation. So that was the first time. It was probably 86, 87, something like that. So we all agreed on a procedure. They would give me their briefs, give them to me, not to each other, because they were still working on their briefs, and they didn't want them each other to see their briefs. And we were going to give you our briefs, and then we want to make our arguments to you in caucus session. I had never caucused before, because I was saying we're all going to hang out here together, all 20 of us, because there were insurance lawyers from whole bunch of different insurance companies and 2 of the major producers who were fighting over who was going to get the insurance benefits. And so we worked out our own little process, almost like a mini trial that some of you may remember from way back when in the early days of ADR. And they did their arguments to me privately. It was actually a very simple legal case. It was about the meaning of an indemnification clause in an insurance contract. So the question was simple, but the stakes were enormous, because it would have been yes or no indemnification or not in this one insurance contract, and the payments were literally close to $1 billion. So the stakes were large, the legal issue was very narrow. And I tell you that story only because I had been lecturing and teaching that facilitative mediation was the only form of mediation that existed. And that evaluation process, as agreed to and designed by the parties, worked for that group. So as I might have said this in March, I say this every time I speak to mediators and arbitrators. My retainer agreement, if you're interested, is now something like 20 pages, single space long. It used to be very little. And the reason for that is I have learned something from every case, and mostly what it says now is you are hiring me to either mediate, arbitrate, or whatever, or we're going to design ad hoc rules and procedures for this particular process. And if we're doing that, these are the rules for this process. And you need to know what those are in advance. And I also expect this from you. So we decide things like whether parties are going to write mediation, not briefs, I never use that word, mediation statements if it's mediation. Briefs are fine for arbitration. But mediation, I'm not deciding anything. Even when I evaluate, I'm just giving my view of what I think might possibly happen to encourage you to go back to the negotiating table. So in mediation, it's a mediation statement, and we decide together whether we're going to share them with each other or they're only going to come to me. And then I require the parties to do some of that creative thinking before they come to me. I promise I won't share this with the other side. That's my caucus by writing. Just tell me what sorts of things you're thinking about, and then we can talk about it. So you don't have to buy any of the things that I do in practice, but to understand that what I'm doing is trying to construct a process that works for the clients in a particular case. One size does not fit all. I describe myself now as a process pluralist. When you hire me to help resolve your dispute, we're going to talk about what fits for your dispute. And my dear friend Frank Sander and I used to go walking in the cemetery to go visit Lon Fuller. It was very sweet. I never met Lon Fuller, but Frank knew that I was a big fan of his. And so we would go to his gravesite, and my wonderful question to him always was, well, Professor Fuller, I would say, I wonder what you think about all these hybridizations, because your articles are all about keeping these processes pure. Adjudication, public, fact-finding, focus on the past, need a resolution. What happened in that bedroom in 1982? We need to know that. Who's lying? We need a decision. This is a case that needs to be public, not private. Then we're going to adjudication. This is a family that needs to work things out. This is a factory that needs to work things out with its workers. We can do that privately, and in the best of all possible worlds, they'll negotiate together, and I'll help the communication, and I'll help them come up with some creative solutions. But they don't need to decide anything. And most importantly, this is the most controversial thing I ever say about mediation. You don't need to find any facts in mediation. There is no reason in many mediations, not all, but there is no reason in a mediation that we actually have to adjudicate. So in my other life as a non-law professor, I would have been an English professor. I love literature, right? And for anybody like me who I taught women's studies for many years at UCLA. We live in the postmodern era, which means, unfortunately, given what President Trump has done about fake news, there is an epistemological theory that we can't actually know the truth a lot. We will probably never know what actually happened in that bedroom. Some of you believe Dr. Ford, some of you may not, but there was no camera there. And even if there was a camera, now we would complain about the camera angle and whether it was actually showing what really happened and when the taping started and when it stopped. So even with cameras, we don't know exactly what happened. But in mediation, we can try to work on a solution for the parties that focuses on the future. Sometimes we need to get into the past a little bit. I'm not saying ignore the past like a lot of mediation training does, which I hate. A lot of family mediation. Think about the children. Think about the future. Don't talk about the past. That's not good either. If there's been a lot of pain in the relationship, if someone has done bad things, whether it's abuse or adultery or other girlfriends or boyfriends, people need to say something about that. But it is a place, a fabulous place when it's done well, for expressing that, for venting, for being able to say what's really important to you. And what's really important to me may not be the same thing as what's important to you. We can express different values in a mediation. And out of those different values, say, well, how do we want to work this out? So I still, of all the dispute resolution processes myself, prefer mediation because nobody has to do anything they don't want to. They may be ordered by courts these days that they have to come, but they don't have to do anything once they get there if they don't want to, most of the time. And it's a process that really empowers the parties. And that's why I'm just going to quickly go into some of my concerns about some of the hybridization. My biggest concern about the hybridization, which I started to say to some of you in the food hour, is I'm an ethics professor, that these processes have different integrities, as Lon Fuller would say, and I would say different ethical requirements. So in mediation, one must disclose if you had any relationship with the parties before. And as I was saying over there, some years ago, I'm trying to think what year, sometime in the 90s, a major national American law firm hired me to do training of their lawyers in all of their offices, just to give them basic training in ADR. They're a firm that does a lot of employment work. And as it turned out, this firm in 6 different cities was using the same very early ADR mediation firm that specialized in mediating employment cases. And I said, so how many cases have you done with this firm? And they basically said almost all of them. And I said, do you tell the plaintiffs and the plaintiffs' lawyers how many cases you've done with this firm? No. Do I have to? Well, as some of you know, have to is a tough question in mediation because a lot of the private associations that support us, the American Conflict Resolution Association, the ABA, AAA, and ACR ethics codes are there, but nobody actually gets punished for anything in mediation except for litigation that happens afterwards. And if you're interested, I don't know if I put this in my set of things. This is in my article, but about 2007, there's an article in the Harvard Negotiation Law Review called Litigating Irony, which is a review of all the cases against mediators up until that time. And a lot of them are conflicts of interest. Some of them are malpractice or mostly coercion, mediators trying to force people to do things they don't want to do. But I believe that these processes all have different ethics rules. The adjudication rules are covered very nicely by our formal ethics provisions. In California, that's a set of separate statutes in the Professions Code. In the rest of the states, it's some version of the ABA model rules. And for those of you who mediate through JAMS or AAA, most of the private institutions have their own ethics rules now. And so you will see that there are different things that should happen in different processes. The most important one for me, and I'll stop there and take your questions. As you could tell, I could go on for hours, but I will not. The most important one for me is not just conflicts of interest, which I think are different. Arbitration conflicts of interest are particularly a problem because you're deciding something. In most of the mediations that I do, I get hired a lot by the same lawyers. And so I say, have you told the other side that you've used me before? And they say, oh, sometimes yes, sometimes no. I tell the other side, do you know I've just done 12 cases with Bill? And they say, fine, maybe you can talk some sense into Bill because we think we're right and we're going to hire you because you may be able to persuade him. Less problematic, I've disclosed my past relationship, but mediation, remember, is still consensual. The parties don't have to agree to anything. Even if I did turn into an evaluator and they didn't like my evaluation, they can walk out. Arbitration's different. So for me, arbitration has a different set of ethical requirements closer to litigation, but also a little bit easier because arbitration also is an agreement of the parties to use that process. So the extent to which it's based on consent, the parties might consent to some things that in a court setting might be considered unethical. And I won't bore you with it tonight, but I have written many, many articles on ethics in international arbitration, which is now a very big issue. And there aren't too many young people in the audience, but one of the reasons that our conflicts of interest is important has to do with one of the values of the Western Justice Center, and that is diversity. Because international arbitration has been dominated mostly by European white males, now a few Brits and a few Americans, but that's because the conflict of interest rules haven't been particularly, there are now several. The International Bar Association has passed some, and the ICC in Paris is talking about finally doing something, but there were no ethics rules really formally. And therefore, the same guys, and I say that intentionally, kept doing cases over and over again. If you have conflicts of interest rules that say if you are continuously arbitrating for the same parties, or worse in international arbitration, flipping sides. Sometimes you're the lawyer in a case, and then sometimes you're the arbitrator. If the conflict of interest rules are stronger to protect the clients, they will also diversify who gets to arbitrate. Because guess what? You're going to have to choose some other people, not the people you keep using over and over again. And so that's my concern. Now, I'll finally end by saying, so I've been writing and speaking a lot about the hybridization. And the final example that you all know of is, just think about it, what happens when courts, which are adjudicators, now require us throughout the world, because the movement is growing, to go do some form of ADR. The extent to which ADR, some of it, mediation certainly, and lots of arbitration, is a product of the parties' consent. What happens when people are being coerced into doing something that we like to think is consensual? So court mandates are also hybridization. Courts are telling people, we want you to try this process, which in its pure Fullerian Menkel-Meadowing form was consent. And similarly, I won't get into it here, but for those of you who know about all of the mandatory arbitration problems in our consumer and health and employment contracts, we are the only country in the world at the moment that has sustained those mandatory arbitration clauses in consumer and employment contracts. They are illegal in the European Union. I do a lot of work in Europe. And again, that is a hybridization that I have issues with. It is taking processes in which the party should be agreeing to use them for whatever good reason, saving costs, time, all of that, and saying, you must do this. If you want our product, this is what you have to do. And I think Lon Fuller would be very upset with that. So I'll stop there. Whoops, I really took up a lot of time, sorry. I do that a lot. Questions? Yes?
So in our courts, I'm a judge in the Los Angeles Superior Court right here in Mosque. We, in our case management, use the word encourage. And so I will say I encourage you to meet and confer on selection of a mediator and scheduling of a mediation. I then back that up with mediation is not always successful. We do have judges who do mandatory settlement conferences. So it's sort of a two-pronged approach. And I think mediation has become so ingrained in our process that even though I'm encouraging, they're hearing, ordering. So if you could just comment.
Yeah, well, that comes because you're a judge. That is the problem. When the judge says, I really strongly would encourage you to do something, people hear, I'm being ordered. And you can try as gently as, I love the word encourage, you can try as gently as you can. That is just built into what happens when a figure of state-appointed authority says, I think you might want to try this. That is why, as some of you know, I actually came to this work from being a federal court litigator in Philadelphia, and there was a magistrate judge, it's on one of my articles, his wife had done a needlepoint thing. It says, to sue is human, to settle is divine. And he was one of the first, he's now deceased, he was one of the first magistrate judges who would do mediation-like settlement conferences. And it worked because the judges, the Article 3 judges, would say, maybe you want to go see Sam. And so there was a separate function. And people, at least in the early days, felt free to say, no, I don't want to see Sam, I want a trial date. And the judge would say, I'll give you a trial date, but in the meantime, why don't you go see Sam? And Sam, another one of these unsung heroes, was one of the early judge mediators. And a lot of my colleagues had trouble with that. The judges shouldn't be mediating. That is another form of hybridization. When I did a lot of work for the Federal Judicial Center. I used to train judges. In fact, I trained Sonia Sotomayor when she was a baby district court judge. It was pretty interesting. The FJC was trying to encourage judges to think about ADR and in referrals, and to tell people in Rule 16 conferences you might want to think about mediation. And this problem came up all the time, especially, big fancy federal courts. When the federal judge says you should try this, people felt like they had to. So the courts that have more money, like Northern District of California or DC or Southern District of New York, actually set up separate offices. So when you file your case, you had to check off one of the ADR boxes, and you could choose what you wanted. So the judge was sort of separated from that. But that's not true in most state systems. Most state systems have what you were suggesting. And it just, I trust you. Again, part of this is all the people who are doing it. It's all in your tone, and to say, I think you would benefit from doing this. Just give it a try. And then if you don't like it, you can come back to trial. So that's why judicial training is very important to me, because I think the judges also have to be educators and tell people what they will get out of these processes and when they might not be appropriate. Yes?
With respect to mediation, since there is no intervention by the court, and it's considered to be one of the pros, wouldn't it also be considered as a con, since if one of the parties after 6 months or after a year, they realize that this is not for them, or they're not happy with the settlement, they could just back out? So wouldn't that be just a waste?
Yeah, so a good program, these days, yeah, the question was, so people go to mediation, couldn't they just, wouldn't it still be sort of okay if they could back out after a certain period of time, right? Yes, the answer to that is yes, and the good programs do that. Good programs say, we will toll, we will stop, we will stay your case for a while, try it, but since it's all voluntary, if one party doesn't want it, just come back and we're not going to make you do it. So that's, that is one way to deal with that. Just put a time limit on it. I'll just tell you one thing that's interesting too. I didn't get to talk about it. In addition to hybridization and process design, figuring out what's the best process, one of the things that's also interesting to me is timing. So when I moved to Washington in the 90s, I was hired by my former court, the Eastern District of Pennsylvania. I was a Philadelphia lawyer at the beginning. And my old court was one of the few 5 federal courts that was authorized to have arbitration in any case then under $75,000. Now the jurisdictional limits have gone higher. And it was very interesting because, just as you say, the parties always felt like they had to. And so the court actually then was interested in constructing some rules for when people could opt out. Was it case types? Could they opt out if it was a constitutional law case, prison civil rights cases? They looked at categories, then they looked at timing. And what I found appalling as a dispute resolution expert was complaint gets filed, 30 days later is the answer, and the Eastern District of Pennsylvania, which had then put in a mediation program, said, you must go to mediation on the 35th day, right after the answer's been filed. What's wrong with that timing?
No info.
Right. I mean, I said, hello, you guys, you're judges. That's positively the worst time. Some people can mediate before they file a lawsuit. Some people will mediate later. But if you're going to do it right after the answer is when the hostility is at its absolute highest. Someone's filed a complaint, and some defense lawyers just deny, put to prove, blah, blah, blah. It's the single worst time. I thought, what kind of system is that? So that's one of the few times in my life I actually felt like I had an effect on something, because they said, discovery. You need some information before you can mediate, and you have no more information on day 35 after you've just filed the answer than before. So they moved it to 6 months. And they said, in 6 months, we'd like you to try to mediate in 6 months, and if it's not making any progress, come back, let us know, we'll give you a trial date. So that's one way to deal with it. Yes?
What do you think the pros and cons of non-legally trained, non-lawyer, but expert mediators that are trained in mediation?
Ooh, that's a great one. So, oh, sorry. You got it? He's fine with it. Okay. So, it's a great question. I was famously infamous some years ago for writing a bunch of articles, short ones, in the CPR Alternatives, among other places, to say that I think in most cases not all mediators needed to be lawyers. And everybody that was not a lawyer got mad at me. So that was architects, engineers, my own accountant in Boston, who got fabulous mediation training at the program on negotiation at Harvard, got really mad at me when I said accountants can't be mediators. And all I mean by that is, I actually, in that setting, I think co-mediation would be great. A lawyer mediator with someone in a construction dispute who is an engineer or an architect. The problem is, if it's a complex case, and I actually got into it, the family mediators also, the psychologists, because they're legal issues. And when people resolve a dispute, certainly in a complex construction case or something like that, they're writing a contract or they're writing an agreement. Now, you could say, as people have said to me, so someone else can mediate the dispute, I agree with that, and then they can go take it to lawyers to be sure that the mediation agreement will satisfy enforcement conditions and all of that stuff. So I've changed my mind over time, since as very sophisticated, good mediators have come from other industries. And I will say, to answer your question, over the years I worked with a Lloyd's of London insurance rep who had no legal training at all. But he was doing so much claims adjustment, and he wound up taking a little bit, I think he did the CPR mediation program, and he's fabulous. So I never say never, never say always. So at the beginning, when I thought, almost every mediation has some legal issue that would require at least someone to know, I can't answer every legal question, I'm not an antitrust expert, but at least I know that there may be an antitrust problem here when I make this agreement, so I better go find somebody. So I'd say now, it would depend. It depends on the dispute, and if the parties want it, mediation's all about party consent. As long as they understand, that's my big ethical issue, do the parties understand what they're getting? And if they want a non-lawyer mediator, and as long as they're aware of, if someone has informed them, you're going to sign an agreement after this mediation, you might want to be sure it's legal enforceable, or what's going to happen if it's breached. That's why I still think there's a little bit of law in almost every mediation. Everybody wants to? Yeah, go ahead.
So could you comment for a moment about non-disclosure agreements and the fact that so much of what's being done privately is not subject to public view?
Oh, God, that's another one of my issues. Yeah. Yeah. So this is so hard for me because this is another place where I'm very unpopular. So in a lot of parts, certainly in the international environment, people that are complaining that investor-state arbitration and a whole bunch of things are too much, and private commercial arbitration, too much behind closed doors. So in the law professoriate in which I live, there's nothing but transparency, transparency, transparency. And my years as a private mediator say, we need privacy in a lot of disputes. Many things would never settle if they had to be aired in open court. And people, more importantly, people would never say what they really wanted if it was out in the public. Most of us that have done really interesting creative deals, my favorite one was saving a museum in the United States. I can't tell you which one. And that was one in which the parties, I did a little caucusing in that one, expressed needs and wants that they could never have done in any public setting. That's why they settled. They didn't want to go to court to reveal various things that were going on in bequests of art and a whole bunch of other things. So it was a very complicated dispute. So obviously I'm very upset, as any feminist would be these days, about the Non-Disclosure Acts and all of these sexual harassment settlements. And that's very disturbing. But I do want to say, I don't say get rid of them always all the time, because I tell you this from my Dalcon Shield experience. A lot of the people screaming that everything should be out in the public are not necessarily victims. Victims want relief. Victims want to be able to complain. They want to get something. Some victims want to string Harvey Weinstein and whoever else, up on the, top of the building or something like that. But there's some victims out there who want some relief and would go to an arbitration or mediation to get relief, and they actually don't want everybody to know. So that is a great question for me, because it falls right into my, blending hybridization thing, and it's one I don't have an answer to, other than for someone who was a Title VII lawyer and is a strong feminist. You can figure that. I am not someone saying, let's get rid of all NDAs. They serve a function, and they actually make settlement possible in some cases. The way to deal with it, I think, might be, clauses that provide exceptions, or I would actually, or a judge, I would actually support various statutory changes that would allow in-camera judges' reviews of when NDAs should be broken for public policy reasons. How's that? For potential legislation. And that would require a bunch of factors. Some overriding public policy need requires us. Well, I say never and never say always, because I think NDAs have a function in the settlement world. There's a lot of things you couldn't settle if you couldn't sometimes require that people not tell other people. But I also believe it's not something that can't be looked at when there are other conflicting grounds for overturning it. That's what our common law system does so well. That's when you go to court. Our common law system says we have a rule, but in this particular case, something else should happen.